preamble. We have some primary discussion on preamble, we did. And let me tell you something very specific about preamble. In our Constituent Assembly, there were discussion about preamble, and scholars, members were very much devoted that the preamble must be taken. And I would say, I am just taking few names like Purnima Chatterjee. She said that our preamble is a charter of freedom. Charter of freedom. Purnima Chatterjee, Charter of freedom. Maulana Hazrat Mohani, he said that preamble is a holy document. Mr. H.V. Kamath called it aspiration of people. Call it aspiration of people. Being optional student, you need to come up with the certain commentaries also. So, these are the people who commented. These are the people who commented on Indian preamble. On Indian preamble, I have already discussed few basic things about preamble, factual information. It was added in the last, or added later part. It was added at the later part. In fact, it was last document to be added, although it was added at front, but it was last document to be added. Then there was a debate, understanding what exactly is preamble. What exactly is preamble? So, we already discussed preamble is gist, preamble is philosophy, preamble set goals, it is purpose, it also reflects nature of Indian polity, aspiration of people, so on. When we say in terms of legality, when we say in terms of legality, I already said it is not source of power. It is not source of power to any institution, person or post. It is institution, person or post. It is not justiciable. When we say justiciable, it means whatever the values are there, one cannot go to the court asking these values has to be, you can say followed, or these values has to be violated. देखिए मैंने ये कहा है कि जैसे सपोज मैं एक एग्जांपल देता हूँ, मे बी यू विल बी एबल टू अंडरस्टैंड. For example, if there is word secularism. There is a word secularism. Now, if government of India make any policy or parliament pass any laws, and if anyone think it is violating secularism. So, secularism could also be derived from rest of the fundamental rights where discrimination on the religion has been prohibited. So, once you will go to the court, you will ask that simple कि it is violating clauses in fundamental right, it is violating clauses in any other part, rather than discussing कि okay, as it has been written in our constitution we should be secular, so these acts are against secularism. When it comes to legality, this cannot be used as the basis of going to court. जब हम जस्टिसिएबल कहते हैं तो इसका मतलब ये होता है कि आप कोर्ट में जा करके उसको अप्लाई करने के लिए नहीं कह सकते हो, ये इसका मतलब होता है. और उसका रीज़न बहुत सिंपल है, बिकॉज these words cannot be explained in a very objective and precise manner. Its meaning varies from person to person, and even perception of certain rules, regulation, laws may differ from person to person. So that is why until unless there is a proper law passed by government which specifically talk about something, then only you go and talk that this is something against the secularism, it is against the socialism. I have given this already this example, like suppose there is a word socialist. Fine, there is a word socialist. In 90s, India went for LPG reforms. You all are aware of this fact. Government policies of disinvestment. Let's go further. Government is following neoliberal line. Now, if anyone go to the court and say it is actually violating value of so court is not going to justify, because in any other part except DPSP, which itself required laws to implement, no other clause is talking about that there must be, you can say, ban on opening up the market or anything. It is nowhere directly mentioned, this one. So you cannot go to the court. But now you say, look, socialism is a part of our preamble, then why should not socialism, these policies should be removed on the name of socialism? That is technically not possible, because as I said, that it is not justiciable. Until unless any clause of our constitution is directly or indirectly violated by a policy framed by government, regulation released by government, or a law made by parliament, one cannot go to the court just referring these values. Now, These values holds importance. In what terms these values hold importance? As I said that it is not source of power and it cannot be used for legal interpretation. It cannot be used for legal interpretation, only as a last resort for directions, giving it a context, then only there is a use of preamble. But apart from that, to understand it is a kind of a key to understand minds of constitutional makers and so on. I am not saying that this preamble has no utility. Preamble has a lot of utility. I will make you right also. But point is the legality or the legal use of preamble. It has big utility. It has a big utility or it has a broader utility. It has a broader utility. It has a broader utility. I guess this is clear to everyone.